Good morning to the Honourable Bench. If it may please the Council seeks permission to address the benches, Your Lordship. Much obliged. May it please this Honourable High Court of Aravali, the Council appears before this Honourable Court in the matter of Sameera Khanna and other versus Mrs. Prisha Khanna and others on behalf of the plaintiff and respectfully submits that this Honourable Court has jurisdiction to adjudicate the present matter under Section 9 of the Code of Civil Procedure 1908, read with Section 16 and 20 of the Code of Civil Procedure and Sections 276 of the Indian Succession Act 1925 governing testamentary jurisdiction. Your Lordships, there are 6 main issues involved in the present case. The Council would be dealing with the first 3 issues and would be speaking for 8 minutes, and my co-counsel would be dealing with the last 3 issues and will be speaking for 8 minutes and reserving 4 minutes for rebuttal. Before proceeding with my submissions, I seek your Lordships' leave to briefly present the facts of the case. Late Mr. Sanjeev Khanna, a prominent industrialist, died on June 12, 2025 in the United Kingdom. He had 2 children, Sameera and Kiran, from his first marriage and maintained a close relationship with them until his death. After his demise, his second wife, Respondent number 1, Mrs. Prisha Sehgal, initially informed the family that he had died intestate and his assets were held under a family trust. On July 30, 2025, Respondent number 1 produced a document dated March 21, 2025, claiming it to be the deceased's last will, allegedly bequeathing his entire estate, approximately 30,000 crore, solely to her, excluding his children and his mother, Mrs. Renu Khanna. The petitioners contend that the will is forged, relying on an affidavit by an alleged attesting witness, stating that she did not witness the signing in the presence of other witnesses, thereby questioning its legal validity. They also allege suspicious conduct by Respondent number 1, including exclusion of the children from official filings, attempt to submit the asset list in a sealed cover, and disappearance of funds from bank accounts. Consequently, the petitioners filed a civil suit before the Honourable High Court of Aravali in September 2025, seeking a declaration that the will is invalid. Notices have been issued to the respondents and the matter is currently pending adjudication. Before I proceed, I seek your Lordship's indulgence to briefly outline the structure of my submissions. I shall be addressing the following key issues. First, whether the purported will dated 21st March 2025 was validly executed in compliance with Section 63 of the Indian Succession Act 1925 and whether its execution can be proved under Section 68 to 71 of the Indian Succession Act. Second, whether the petitioners can prove that the purported will is forged or fraudulently caused, thereby attracting criminal liability under Section 467 of the Indian Penal Code and warranting a concurrent criminal investigation. Third, whether the court's power to receive the alleged will and sensitive documents in a sealed cover or subject to confidentiality conditions is legally permissible and consistent with the fundamental principles of open justice. If it pleases this Honourable Court, I shall proceed with my first submission. Much obliged. Your Lordship, the first issue challenges the validity and proof of the purported will. The counsel for the petitioner contends that this document is inadmissible and void. We shall establish this condition on 3 primary grounds. First, that the fatal non-compliance with the statutory requirements of valid attestation. While also in the first ground, it is a humble submission that the validity of a will is contingent upon strict adherence to Section 63 subsection C of the Indian Succession Act 1925. The section mandates that a will must be attested by at least 2 witnesses who have seen the testator sign and has signed the will in the presence of the testator. This is not a mere formality but a statutory imperative. Reliance is placed on the judgment in Janki Narayan Bhor versus Narayan Namdev Kadam, where the Honourable Supreme Court established the doctrine of animo attestendi. The court held that attestation is diagnostic, conscious and uninterrupted act of verification. A mere mechanical signature without the intent to attest the complete execution does not satisfy the law. Applying this ratio to this case, to the present matter, it is submitted that the impugned will is statutorily defective. The affidavit of the purported will, that is Ms. Shruti Suri Malhotra, contains a dispositive admission that she departed shortly before the signing was complete. Since she did not witness the completion of the execution, the chain of animo attestendi was fractured. Consequently, the mandatory requirement of Section 63 subsection C stands violated, rendering the will void ab initio. The second ground is that the failure of the respondents to discharge the burden of proof under the Indian Evidence Act. My lords, the principle of law under section 68 of the Indian Evidence Act 1872 places a solemn and heavy burden on the propounder to prove due execution. Furthermore, section 71, which allows other evidence to be led, is only applicable when a witness denies or does not recollect execution, not when a witness positively affirms a defect in execution. Reliance is placed on H. Venkatachala Iyengar versus B. N. Thimmajama, where the Honorable Court held that the propounder must dispel all legitimate suspicions surrounding the will. The court emphasized that if the attesting witness fails to prove due execution, the will cannot be admitted to probate. In the instant case, the respondent's own witness has provided positive evidence of non-compliance by admitting she was not present for the full execution. She has effectively testified against the validity of the will. The respondent cannot seek refuge under section 71 to cure this defect, as the witness has not forgotten the event but has confirmed its invalidity. Therefore, the onus of proof remains undischarged. The ground 3 is that the existence of unexplained suspicious circumstances that shock the conscience of the court. My lords, it is a settled principle where the execution of a will is surrounded by suspicious circumstances. The conscience of the court must be satisfied before the document is accepted. Any unnatural disposition or secrecy raises a presumption against the genuineness of the will. Reliance is placed on Jaswant Kaur versus Amrit Kaur case in the year 1977, where the Honorable Court held that the propounder bears a heavy burden to explain any circumstance that provokes judicial suspicion. Applying the precedence to the present case, the will is clouded by a constellation of suspicion, that is unnatural disposition, that is he disinherited his minor children and his aged mother from the will, the systematic concealment where the respondents wanted to cover the asset in a sealed cover and NDAs, and the fiduciary overreach where the respondent appointed herself as sole executrix with power to override jurisdiction. Therefore, my lords, in the light of the statutory violation of section 63, the failure of evidentiary proof under section 68 and the overwhelming suspicious circumstances, it is our respectful submission that the purported will is nullity and must be discarded. If it may please the Honorable Court, shall I proceed with my second submission? Your Lordships, the second issue concerns a serious allegation of forgery. It is a humble submission that the impugned will is a fabricated document created to misappropriate the deceased estate. We rely on three primary grounds. That is, first, that the will is surrounded by suspicious circumstances and fraud. The law is clear, the burden to prove a will lies only on the propounder. However, when there are suspicious circumstances, this burden becomes heavy. The propounder must explain these circumstances to satisfy the conscience of the court. Reliance is placed on Jaswant Kumar versus Amrit Kaur, where the Supreme Court held that the propounder must dispel all legitimate doubts. Further, in Niranjan Umesh Chandra Joshi versus Mrudula Jyoti Rao in the year 2009, the court held that if a sole beneficiary takes an active part in the execution and excludes natural heirs, the court must be extremely vigilant. Moreover, the document is legally defective. The purported witness, that is Ms. Malhotra, admitted she left before the signing was complete. This admission means that there was no valid attestation under the law, rendering the will non-existent in the eyes of the law. The second ground is that these acts constitute forgery of a valuable security under section 467 of IPC. My lords, a will creates a right to property, therefore it qualifies as a valuable security. Fabricating such a document falls under section 467 of IPC, which deals with forgery of valuable securities. Under section 463 and 464 of IPC, making a false document with the intent to cause wrongful gain is defined as forgery. In this case, your lordships, the facts clearly shows a prima facie case of forgery. First, the defect, that is the witness herself admitted the execution was not done properly. Second, that the motive, the respondent excludes all other heirs to take the entire 30,000 crore estate. And third, the conduct, the respondent first claimed that there was no will, then suddenly produced this will. This sequence shows a clear mens rea of guilty mind to deceive the petitioners and this honorable court. Third, regarding jurisdiction, we rely on Iqbal Singh Marwa versus Meenakshi Marwa of the year 2005. Since the forgery occurred before the document was filed in court, there is no bar on a criminal investigation. We pray that this honorable court exercises its duty under section 340 of CRPC to direct an inquiry as the fraud here is palpable. May I go forward with the next issue? Much obliged. My lords, the respondent request for sealed covers and NDAs is legally unsustainable. First, it violates the rule of open justice as held in Naresh Mirajkar versus State of Maharashtra in the year 1967. Rare exception, secrecy is a rare exception, not the norm. The respondent has shown no demonstrable necessity to hide these documents. And second, it violates natural justice by concealing the asset list. The respondent is effectively blindfolding the petitioners. We cannot contest the depletion of assets if we cannot see the accounts. This violates the principle of audi ultim partem. Finally, demanding an NDA form, counsel acts as an unconstitutional gag order without any legal basis. Unless your lordships have any other further question, that concludes my arguments. Your lordships, my co-counsel will be dealing with the last three issues. The council is grateful to this honorable court for the time afforded. Sorry, my lord, you're not audible. Yes. Yes.
Then why to disbelieve that affidavit?
Sorry, I am not audible.
You have not followed.
You're not that audible, my lord.
Here, after execution of will,
Yes.
one witness has filed affidavit on record.
Yes.
Then what is reason to disbelieve that affidavit?
My lord, she has already said in the affidavit that she has left before the execution of the will. So that is already not complying with section 63C of the Indian Succession Act. So that is why we are not relying on the affidavit. If you have any other further questions.
Before proceeding with the substantive submissions, the Council respectfully seeks your Lordship indulgence to briefly outline the structure of the argument. The Council shall address the following key issues. Fourth, whether the plaintiffs are entitled to interim protection based on the prima facie case, balance of convenience and irreparable injury test. Fifth, whether the Ms. Kajol Khanna, the petitioner, as the natural guardian can represent the minor's petition as a next man without a separate court order and safeguard order under Order 32 of CPC. And lastly, the relief. The will is set aside, including the declaration of intestacy, transfer of accounts to class 1 higher, and criminal proceeding for compensation. If it pleases this honorable court, I shall proceed with my first submission. Your Lordship, this issue is about urgency. The petitioner seeks immediate protection to the estate freezing orders, including the freezing orders and the appointment of the receiver under the Order 39 of the CPC. We submit that we satisfy the right trace for granting injunctions on 4 primary grounds. First, that we have a strong prima facie case. My lords, on the first ground, the law requires to show prima facie case. We rely on the standards set by Dalpat Kumar versus Prahlad Singh, with the court held with the existence of the serial legal question is tried sufficient. As established in H. Ventinkal Iyengar versus B.N. Timmajama, which is a 1959 case, the presence of suspicion circumstances surrounding will surrounds the challenge, strengthens the challenge against it. Your Lordship, our case is built on substantial evidence. First, the admission. The witness herself admitted that she did not see the full execution, the suspicion, the unnatural disinheritance of the minor children, and the duress Ms. Renu Khanna was forced to sign the documents. These facts clearly establish a prima facie case that the will is invalid. The second ground, that there is an imminent threat of irreparable injury due to the asset dissipation. My lord, we must show irreparable injury. This means the harm that cannot be fixed by money later. This Honorable Court under section 151 CPC has inherent power to prevent such injury by protecting the subject matter of the suit. My lords, the injury here is neither hypothetical nor distant. It is immediate and directly unfolding. We have placed on the record that specific bank accounts and receipts are being systematically wiped off. This is not merely a fear of future loss, but an ongoing destruction of the estate's value. If this honorable court does not intervene now, the 30,000 crore estate risk being alienated and transferred.
Do you have any evidence on this?
There's a annexure C. There's a bank statement. There's 30.
Is it
10
certified?
No, it's 15,000 has been wiped off from the account.
No, that bank statement is certified,
Yes.
or it is just a statement?
No, it's a certified. It's given in the annexure C.
Annexure C.
Yes. It's submitted to the court bench. Okay. The next is the balance.
May you please continue?
Okay. The third ground is the balance of convenience. On the third ground, my lords, we look at the balance of convenience. We must ask who suffers more if the injunction is refused. Reliance is placed on Zenith Metaplast Limited versus State of Maharashtra, where it was held that the core purpose of interim relief is to preserve the subject matter of the suit so the trial remains meaningful. Your Lordship, the balance is entirely in our favor. Granting a freezing order merely preserves the status quo. It keeps the money safe until the trial is over. It harms no one. However, refusing the order risks the total loss of the estate. Therefore, justice demands that the estate to be frozen. The fourth ground is that the appointment of the receiver is necessary to ensure transparency. My lords, regarding the appointment of the receiver, when a party in the possession of assets is acting suspiciously or hiding information, the court can appoint an independent receiver to protect the property. The respondent is hiding behind the sealed covers and refusing the disclosed bank statement. This lack of transparency is dangerous. We need an independent receiver to manage the estate impartially and prevent the respondent from using the estate's. Huh? Okay.
Your time is already over.
If the May please, Your Lordship, I humbly request you 2 minutes to briefly summarize my last submissions. Okay, clause, okay, I'll go with the prayer clause. If it pleases the Honorable Bench for the foregoing submissions, it is most respectfully prayed that this Honorable Court may please to declare the property will dated 21st March 2025 void and hold the late Sanjeev Khanna death intestate. Recognize the petitioners being class 1 heirs as entitled to their lawful share in the estate. Direct a court supervised accounting and protection of the estate assets. Award appropriate costs and compensation and pass any other order that this Honorable Court may deem fit in the interest for the justice. Much obliged, Your Lordship. The Court Counsel is grateful to this Honorable High Court for the valuable time afforded.
Counsel seek permission collectively to address the bench as Lordship. If Lordship is familiar with the statement of facts, then Counsel seek permission to move towards issues. Much obliged. Your Lordship, issue number 1 concerned with whether the bill validated at 21st March 2025 was validly executed under Section 63 of Indian Succession Act and Section 68 to 71 of Indian Evidence Act. May it please Your Lordship, Section 63 requires 3 mandatory conditions. First, the testator sign, 2 attesting witness required, and witness must sign in presence of testator. Here, please refer the annexure of A Ms. Shruti Suri Malhotra and Mr. Amit Mehta, fulfilling their statutory mandate, will bear the signature of both attesting witnesses. Supreme Court in N. Kamlayam versus Ayyar Swamy clarified that attestation witness required animus attestandi, intention to attest. And further in Janki Narayan Boyer versus Narayan Namdev Kadam, the court held that attesting witness need not sign in front of attesting witness need not sign at the same time. Sequentially applied here. Therefore, minor technical objections are not invalidate a will. Section 68 of Indian Evidence Act states that only one attesting witness is required to prove the validity of a will. Here, mere suspicion is not raised, the will is invalid. Once execution is proved, the burden shifts to the challenger. As laid down, Niranjan Umesh Chandra Joshi versus Mrudula Jyoti. Under the Krishna Kumar Billa versus Radhendra Singh Lodha, probate courts only examine genuineness and due execution, not the title of ownership. Therefore, in light of statutory compliance, Annexure B and settled law, the will dated 21st March 2025 stand validly executed and duly proved. If lordships are satisfied with issue 1, then council seeks permission to move towards the issue number 2. Much obliged. Issue 2, whether the plaintiff have discharged or can discharge the onus of proving that the purported will forged, fabric or caused fraud, undue influence. May it please your lordship. The offence of forgery under section 463 and 464 state that makers of false documents. Here, petitioner does not submit that defendants make a false and alleged will. Therefore, section 467 of IPC is not applied here. Allegation of forgery, fraud, undue influence required clear and strong evidence. In H. Venkatacharya Iyengar versus Thimmaji and Shashi Kumar Banerjee versus Subodh Kumar Banerjee, Supreme Court clearly stated that mere suspicion is not enough to cancel the will. Burden of proof lies on the person who makes the allegations. This is submitted by Latin maxim, actori incubit once propendi. Just because the will benefit to one person is not invalidate it, even if beneficiary is present at the time of signing, it is not raised that the will is suspicious. Disputed does not automatically become a false document under criminal law. The Supreme Court in G. Sagar Suri versus State of UP warned against turning civil disputes into criminal liabilities. If the plaintiff believes that this is a criminal case, then plaintiff have to approach the criminal courts. Therefore, the plaintiff have failed to prove forgery, undue influence requirement of section 467 of IPC is not satisfied. My learned friend relied on section 195 and 340 in her argument. Mere allegation of forgery will not enough to use 195 and 340 of CRPC. Those apply only when there is a clear first-hand material that a crime has been committed in relation to the case itself, and when the court feels a criminal case is really necessary to protect justice, not simply because the will is challenged. If lordships are satisfied with issue 2, council seek permission to move towards issue 3. Much obliged. This issue concerned with whether the court direction receive an alleged will and sensitive financial documents in sealed covered and to impose confidentiality safeguard is legally permissible and constitutionally valid. May it please your honorable bench. The honorable court has inherent power under section 151 of CPC to regulate its own procedure to secure the end of justice. The Supreme Court in Padma Sen versus State of UP and Manohar Lal Chapra versus State Hiralal has affirmed that court possesses inherent power authority to prevent abusive of process. The petitioner challenge is premature as held in Kashinath Sansthan versus Srimad Sudhindra Trita. Unless a prima facie case is established, question of balance of conveyancing or alleged prejudice don't arise. The maxim, salus populis supreme lex, the welfare of the people is the supreme law. This is rupees 30,000 crore state confidentially protect corporate established market confidence and public interest. Control confidentially prevents unnecessary media trials and public speculations. Importantly, the order grateful access of the petitioners counsel, they can examine, challenge and argue on every document. There is no denial of natural justice. Natural justice requires denial of opportunity. No, Lord. No, Lordship, because it is it is a huge amount, 30,000 crore, and other properties, and it is clearly mentioned that petitioner can argue on behalf of it, but it is not disclosed in public. Financially assets information forms part of informational privacy protection under Article 21 as recognized Justice Case Puttaswamy versus Union of India. The seal cover order satisfies the proportionality test laid down in Modern Medical College versus State of MP. Protection of privacy, security and market stability. Second, sealed cover prevents the misuse of highly financial states. Third, council has assessed only public disclosure is restricted. There is no impairment of adjudication rights. While open justice is a foundational principle, it is not absolute. In Naresh Sridhar Mirajkar versus State of Maharashtra, the Supreme Court held that the may restrict public access when necessary for the administration of justice. Further, SP Gupta versus Union of India and Dinesh Trivedi versus Union of India clarified that limited non-disclosure is permissible in large public interest, provided it is narrowly tailored to subject to review. The present order is interim, reviewable, and confined only to genuinely sensitive material. It therefore meets constitutionally validity. The sealed cover directive is procedurally valid, constitutionally balanced, and necessary safeguard. It protects privacy, commercial stability, and public interest without affecting the petitioner's right to fair hearing. The challenge is therefore legally unsustainable and deserve to be rejected. If Lordship is satisfied with issue 3, with all 3 issues, then Council seek permission to respectively conclude it and concluded my submission. My learned co-counsel will address the remaining issues. Much obliged.
In this matter, if interim relief is granted,
Sorry,
then
Lord.
how you are going to be affected?
If interim relief is granted, then how you are going to affect?
Because it is on initial stage. If interim release is granted, then salary and other any business statutory any business establishment is affected, because salary allowances of laborers and many things, and everything is depend on it. That's why interim release at initial stage does not granted.
Yes.
Much obliged.
May it please your lordship, co-counsel seek permission to refer issue number 4. Much obliged. The fourth issue before this honorable court is whether the plaintiff are entitled to immediate interim relief, freezing orders, injunction under order 39, appointment of receiver, disclosure of bank accounts to prevent dissipation of alleged assets, test to grant injunction. Your lordship, the above reliefs are extraordinary equitable remedies. They are not granted as a matter of course upon filing a suit, but require strict satisfaction of the triple test under order 39 of CPC that required a prima facie case, an irreparable injury, and balance of convenience. Here, the plaintiff have failed to establish a prima facie case. A mere challenges to a will does not automatically justify interference with its administration. The defendant in lawful control of these estate until credible evidence of fraud, invalidity, misconduct shown, the state must be allowed to operate in its ordinary course. As held in the case of Dalpat Kumar versus Prahalad Singh, that a prima facie case requires a substantial question of law supported by credible material, not mere allegations. There is no irreparable injury demonstrated by plaintiffs. The states are identifiable under the lawful management. There is no evidence of concealment and diversion or destruction. Speculative fear of possible dissipation does not meet the threshold of irreparable harm. The appointment of a receiver is a drastic step for a case where property is in imminent danger of waste or mismanagement. No such emergency existed here. A blanket order for disclosure of all bank demat accounts amounts to fishing inquiry at an interim stage without demonstrating specific necessity. As in the case of Silvey versus Arun Varghese, the court had consistently held that an injunction can't be used as a tool for premature execution of a decree before rights are established. Interim relief is meant to preserve the status quo, not grant premature advantage. There is no urgency, not demonstrated risk, no irreparable injury. That the application must therefore be rejected. If Honorable Court is satisfied with this submission, may I move towards? Much obliged. The fifth issue before this Honorable Court is whether Kajal Khanna can act as a next friend, represent the minor plaintiff without any additional court appointment, and what are the safeguards under Order 32 of CPC. It is respectfully submitted that the Kajal Khanna status as the mother of minor plaintiff does not confer an automatic or vested right to represent them, their natural friend, next friend. Under Order 32 of CPC, Civil Procedure Code 1900, the appointment of next friend is subject to strict judicial supervision to ensure the minor interest remains free from conflicts. Order 32 Rule 1 of CPC requires a minor to sue through a next friend, but the court retains a duty to examine the suitability of the proposed representative. In the present case, Kajal Khanna is the former spouse of the testator and personally involved in litigation concerning the state. As in the... Yes, yes, Your Lordship. Your Lordship, she is also personally involved in litigation of the present case for the state, so it may be some influence. Yes, Your Lordship. But Your Lordship, with the interest of minors, yes, Your Lordship, but here the litigation involved concerning a huge state. She is also in... Your Lordship, it is not... because the... Yes, Your Lordship? Yeah. Your Lordship, there is a connection between the children and a mother, and there might be undue influence out of love and affection. Maybe
It is proved on record.
no, Your Lordship.
You carry on.
Much obliged. A legal maxim, nemo judex causa sua, that provide no one should be a judge in his own case. Order 32 of CPC provides continuing safeguards. Rule 3 permits appointment of a guardian ad litem. Rule 7 prohibits compromise without court approval. And Rule 9 empowers the court to remove an expert whose interest is adverse. This provision noted in Rukhamabai versus Lala Lakshminarayan shows that the authority of an expert is supervised, conditional, and revocable. The law governing minors is built on the principle that justice must not only be done, but must be seen to be done free from parental conflict. Her request to act as an expert therefore deserves to be rejected. If your lordships are satisfied with this submission, ma'am.
Will do not show any provision for old mother.
Yes, your lordship.
The will which has been executed
Yes, sir.
do not show any provision for old mother. Then in such circumstances, what is to be seen?
For what your
Talking about the Kajal Khanna, the earlier
Ah.
mother.
Mother of the deceased who has executed will deed,
yes.
but that will deed has no provision for old mother. So whether this will can be relied?
Yes, your lordship, but it is the testator's wish. He executed it is in his own sense while making the will. So we have to respect his last will.
Is all the property self-acquired or ancestral?
No,
Bifur-
there is not a clear cut that. There is in the fact it is mentioned that she alleges what you say. Can you repeat?
The property is ancestral or self-acquired?
In the present fact, the mother said that it is by her transferred by her husband, but it is not declared that it is a ancestral property.
Time is over. Come with the prayer clause.
Okay. In light of the fact stated, issue raised, argument advanced, and authorities relied upon, it is most humbly prayed that this honorable court may be pleased to dismiss the present suit as being devoid or of demerit and unsupported by evidence, uphold the validity of the will dated 21st March 2025 and recognize the defendant as a lawful executrix and beneficiary, reject the allegations of forgery, fraud, and undue influence as baseless, deny all interim reliefs including freezing of assets, injunction, receivership, and blanket financial disclosure, hold that no criminal proceeding arise from the present suit. Dispute is in the absence of prima facie evidence. Pass any other order, direction that this honorable court may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the defendant shall, as in duty bound, ever pray. Much obliged, Your Lordship.
Any reply? Whether there is any ambiguity? What you want to clarify?
Hello?
Yes.
Yes, Your Lordship. I did not get your question.
What reply you want to give?
Yes, yes, Your Lordship. I would like to make a brief rebuttal on the following points. My lords, independent of CPC, Ms. Kajal Khanna has a substantive right under Section 6 of the Hindu Minority and Guardianship Act 1956. The mother is a natural guardian of the minors after the father's demise. Your Lordships, as the natural guardian, she has a fiduciary duty to protect her children's property. By challenging a forged will that disinherits them, she is fulfilling this statutory obligation. Her interests are perfectly aligned with the minors. She is fighting for them. My learned friend also claims that the will is valid and execution is proved by Miss Shruti Malhotra. The deceased died on 12th June 2025. The will was only disclosed on 30th July. If the will is genuine and the defendant number 1 is the sole beneficiary, why was the document suppressed for nearly 2 months? This delay creates a suspicious circumstance that the propounder must explain why they have failed to do, which they have failed to do in their arguments. Then second is Miss Shruti Suri Malhotra is the executor and attesting witness, and executor has an interest in the will. Did they examine the second witness, that is Mr. Amit Mehta? They relied solely on the testimony of the executor.
1 minute.
Okay, Your Lordship. My learned friend has also submitted that the plaintiffs are merely entitled to the statutory shares according to section 8 upon class 1 heirs, but according to section 10 of the Hindu Succession Act, it is said that among the heirs in the branch of the predeceased son shall be made so that his widow and the surviving sons and daughters get equal portions of the property.
Yeah, we got the point.
Much obliged.
Just give me a minute, I'm joining the yeah.
Hello. The council seeks permission to address the honorable bench as your lordship. Much obliged. If the honorable court is well versed with the statement of facts, I would like the council would request to proceed with arguments. Your Lordship, the first issue deals with validity and proof of the purported will. Whether the purported will dated 21st March 2025 has been validly executed in compliance with Section 63 of the Indiana Succession Act applied perimeteria, and whether its execution can be proved under the Section 68 to 71 of the Indiana Evidence Act. The plaintiffs argue that the purported will dated 21st March 2025 is not proved in terms of Section 63 and Section 68 to 71 of the Evidence Act, as the attesting witness Shruti admits that she left before the signing was complete and cannot confirm that both witnesses signed in the testator's presence. The propounder has not shown that the testator understood or approved the contents, nor that due attestation actually occurred, while grave suspicious circumstances, total exclusion of minor children and aged mother, transfers timing close to deaths, and the clause making the executive decision final and binding remains unexplained. The council seeks permission to proceed with issue 2. Much obliged. Issue 2 deals with allegation of forgery and its legal consequences. Whether the plaintiffs have discharged or can discharge the onus of proving that the purported will is forged, fabricated, or caused by fraud or undue influence. Whether the acts, if proved, attract criminal liability under the Indiana Penal Code Section 467 applied perimeter. Whether a civil court should and can direct a concurrent criminal investigation. The plaintiff most respectfully submit that the children and the testator's mother specifically allege forged signatures and fabrication of the will in collusion with attesting witnesses, supported by the court's order entertaining a prayer for forensic examination. The large allegedly posthumous digital transfer to Prisha from Zenith Bank account of late Sanjeev Khanna, alongside a will giving her entire estate and the control of all the assets, indicate a pattern of fraud and undue influence in the relationship of dominance, justifying both setting aside the will and directing investigation for offences including forgery of a will. The council seeks permission to proceed with issue 3. Much obliged. The issue 3 deals with confidentiality, sealed covers, and non-disclosure agreements, hereinafter referred to as the NDAs. Whether the court has power to receive the alleged will, asset list, or sensitive documents in sealed cover, and to impose confidentiality conditions or to insist on NDAs for counsels is permissible and or justiciable in the facts of this case, and whether an order permitting sealed cover files can be challenged as violating the principles of open justice or public interest. The plaintiffs respectfully submit that the court has already limited sealed cover use to the interim stage and held the proposal to compel NDAs for the counsel problematic and without legal basis, affirming that the adversarial fairness cannot be compromised by confidentiality devices. Any continued confidentiality must be narrowly tailored to avoid media sensationalism without restricting plaintiff's inspection or cross-examination at the trial. The will and the asset list should be treated under the norm of open justice and not broad secrecy. The counsel seeks permission to proceed with arguments advanced. Much obliged. Issue 1. The central question is not whether the will bears the signatures, but whether it stands proved in the manner required by the law. Section 63 of the Indiana Succession Act, applied perimeter, mandates due execution and attestation by at least 2 witnesses. Section 68 of the Evidence Act, applied perimeter, requires examination of at least 1 attesting witness. However, the compliance is not merely formal. As held in H. Venkatachal Iyengar versus B. N. Thimajamma, the Honorable Supreme Court held that where suspicious circumstances exist, the propounder must remove them to the satisfaction of the judicial conscience. The burden remains entirely on the propounder. Further, as held in Jashwant Kaur versus Amrit Kaur, it was held that when a will excludes the natural heirs, class 1 heirs, or appears unnatural, the onus becomes heavier. In present case, there is complete exclusion of class 1 heirs, substantial financial transfers preceding death, and delay in disclosure of the instrument. These circumstances, viewed cumulatively, raise legitimate suspicion. As reiterated in Rani Purnima Devi versus Kumar Khagendra Narayan Dev, mere denial of suspicion is insufficient. The propounder must affirmatively explain the surrounding circumstances. An affidavit may prove the signature, but it cannot establish any free, voluntary, or conscious execution of the will. Therefore, the plaintiff respectfully pray that unless this honorable court's conscience is fully satisfied, the will cannot be declared valid. The counsel seeks permission to proceed with issue 2. Much obliged.
Here, as per requirement, yes, as per requirement, one of the witness has been examined.
May I respectfully clarify, my lord?
Yes.
The affidavit of the witness Shruti Suri Malotla clearly states that she left shortly before the signing was done, and she cannot confirm whether both the witnesses and the testator signed in her presence. She also has not confirmed that the will was read aloud in front of her. So, forgery can be presumed here. The counsel seeks permission to proceed with issue 2.
Yes.
Much obliged. The respondents contend that the plaintiffs have failed to discharge the burden under section 104 of the BSA With respect, this submission misstates the nature of present proceedings. Section 104 applies when a party relies upon the existence of a particular fact to make the evidence as admissible. Here, the primary burden of proving genuineness of the will remains upon the propounder under Section 101. The plaintiffs are not required to prove forgery as a criminal charge. They are entitled to challenge the genuineness and demand strict proof. The absence of recorded objection during the 37-day period between the death and the bank transfer does not validate the transaction. My lord, silence cannot be equated with consent, particularly where control of finances and control of all the assets is with the widow and are disputed. The timing of substantial transfer immediately preceding death is a relevant surrounding circumstance. It is correct that not every unusual circumstance invalidates a will. However, the same judgment by the Supreme Court recognizes where the circumstances excite the suspicion of the court, they must be satisfactorily explained. Here, the deceased had already constituted a family trust for Samira and Kiran. A sudden deviation from established estate planning strengthens the doubt for the plaintiffs. The present proceedings concern civil validity of a testamentary instrument. Absence of criminal prosecution does not establish its authenticity. The plaintiffs are not required to prove fabrication beyond reasonable doubt. They must demonstrate credible circumstances, casting doubt that threshold stands satisfied. The counsel seeks permission to proceed with issue 3. Much obliged. The respondents justify sealed cover proceedings on the ground of privacy and commercial sensitivity. With respect, confidentiality cannot override the procedural fairness. The Honorable Supreme Court in Madhyamam Broadcasting deprecated excessive reliance on sealed cover procedure and reaffirmed that open justice is a constitutional norm. Sealed cover is an exception, not a default mechanism. Section 151 preserves inherent powers of the court, but such power cannot be exercised in a manner that prejudices a party's right to effectively contest the case. Confidentiality cannot translate into evidentiary asymmetry. 30,000 crore industry, market fluctuation, hostile takeover risks, etc. Mere apprehension of market reaction cannot justify withholding material documents from contesting a hire in a testamentary dispute. My lord, the plaintiffs are not members of the public. They are direct stakeholders in the estate. Limited disclosure under restrictive conditions does not cure procedural imbalance if the material facts remain shielded from the meaningful challenge. The right to privacy is recognized, but it must be harmonized with the right to fair hearing. A sealed cover cannot become a shield against a scrutiny. The power to seal documents must be exercised sparingly, proportionately, and only when strictly necessary. In the present case, the complete financial opacity directly affects the adjudication of the testamentary intent. Therefore, greater transparency is warranted. The counsel seeks permission to hand over the...
Yes.
Your Lordship, the Council will be dealing with the issue number 3, 4, 5 and 6. The Council seeks permission to move on to the 4th issue. Much obliged, Your Lordship. Your Lordship, the 4th issue is whether the plaintiffs are entitled to immediate interim reliefs, freezing orders, injunction under Order 39 CPC, appointment of receiver, disclosure of bank demat accounts to prevent dissipation of alleged assets, tests to grant injunctions. The Council argues that a seriously disputed and suspicious will, alleged forced transaction and a massive estate create a strong prima facie case in favor of minor plaintiffs. To prevent dissipation, making any decree illusory, the court should grant injunctions order under 39 CPC, compel full disclosure of bank demat accounts and trust assets, and if needed, appoint a receiver as status quo protection outweighs any inconvenience to the widow who can be granted reasonable maintenance from the estate. Your Lordship, the Council seeks permission to move on to the 5th issue. Much obliged, Your Lordship. Your Lordship, the 5th issue is whether Kajol Khanna, mother, can act as next friend, represent the minor plaintiffs without any additional court appointment, and what are the safeguards under Order 32 CPC, example for removal of next friend, appointment of guardian ad litem. The council argues that under Order 32 CPC, Kajol as mother is the most natural next friend with no shown conflict since she asserts only her children's inheritance rights against an allegedly forged will. The court retains continuing power to supervise, replace the next friend, or appoint a guardian ad litem and vet any compromise, ensuring the minor's interests are fully protected. The council seeks permission to move on to the sixth issue. Much obliged, Your Lordship. Your Lordship, the sixth issue is what is the correct relief if the purported will is set aside? That is, declaration of intestacy and distribution under the Hindu Succession Act, Class 1 heirs, grant of accounts, directions to transfer assets to plaintiffs, compensatory relief, and criminal proceedings. The council argues that once the purported will is declared invalid, the estate devolves intestate under the Hindu Succession Act pari materia with the widow, son, daughter, and mother, Prisha, that is Prisha, Azhar, Samira, Kiran, and Renu Khanna, each entitled in principle to equal shares. The plaintiffs seek declarations of intestacy, full accounts, correction of corporate and beneficiary records, restoration of assets wrongly dealt with under the impugned will, and initiation of appropriate criminal proceedings so that the minor statutory shares are secured and the estate is not dissipated. Your Lordship, the council seeks permission to move on to the arguments advanced.
Yes, continue.
Thank you, Your Lordship. Your Lordship, the fourth issue is freezing of assets. The respondents contended that the plaintiffs have failed to establish the threefold test under Order 39 rules of 1 and 2 CPC. With respect, the submissions overlook the nature of the present dispute. In Dalpat Kumar, the Supreme Court held that a prima facie case does not mean proof to the hilt. It means a serious question requiring trial. The validity of the will, substantial financial transfers preceding death, and exclusion of Class 1 heirs undoubtedly raise serious triable issues. That threshold is satisfied. The plaintiffs do not seek operational paralysis of Khanna Industries. They seek preservation of disputed estate assets pending adjudication. If estate assets are alienated, transferred, or encumbered during pendency, the injury to lawful heirs would be irreversible. Corporate inconvenience cannot outweigh irreversible depletion of inheritance rights. The balance of convenience lies in maintaining status quo, not in permitting irreversible transactions. The Supreme Court has emphasized that courts must prevent irreversible changes during pendency of suits concerning property rights. Preservation protects both sides. Dissipation prejudice is only one. The plaintiffs have demonstrated a serious triable issue, potential irreparable harm, and a balance of favoring preservation. Therefore, interim relief is not punitive, it is protective. The council seeks permission to move on to the fifth issue. Much obliged, Your Lordship. The fifth issue is, Your Lordship, the respondents challenge that maintainability by alleging adverse interest under Order 32 CPC with respect that allegation is speculative and legally unsustainable. Order 32 Rule 4 CPC permits any person of sound mind and majority to act as next friend, provided his or her interest is not adverse to that of the minor. The test is actual conflict, not presumed hostility. Under Order 32 Rule 9 CPC, removal of a next friend requires clear proof of prejudice or adverse interest. The existence of a prior trust does not eliminate the minor's interest in the remaining estate. Challenging a disputed will strengthens rather than weakens the minor's propriety interest. A next friend who seeks preservation of estate assets cannot simultaneously be said to be acting adversely. Matrimonial history between spouses does not create automatic legal adversity in matters concerning children's inheritance. Allegations of media involvement do not establish legal conflict. The test remains whether the minor's financial interest is compromised. No such prejudice is demonstrated. Unless concrete evidence of conflicting proprietary interest is shown, the drastic step of removing a next friend is unwarranted. The plaintiff's actions seek to secure, not diminish, the minor's estate. Your Lordship, the council.
Yes.
Thank you, Your Lordship. Your Lordship, the sixth issue is remedies and reliefs if the purported will is set aside. If the purported will is declared void for lack of due execution proof, forgery, or undue influence, the estate devolves intestate. Under the Hindu Succession Act, the widow, sons, daughter, and mother are Class 1 heirs. In this case, that includes Prisha, widow, Azhar, son, Samira, daughter Kiran, son, and Renu, mother, each presumptively entitled to an equal share, subject to what is established regarding valid pre-existing trust or transfers. Plaintiffs are entitled to full rendition of accounts of all dealings with the estate after the testator's death, including the disputed bank transfer and subsequent movement of assets, and to restitution or transfer of properties and funds alienated under the color of the forged will. Corporate and beneficiary records must be rectified to reflect the lawful rights of Class 1 heirs. Your Lordship, the Council seeks permission to move on to the prayer. In the above premises, it is mostly humbly prayed, and this Honorable Court may be pleased to declare that the document dated 21/3/2025 described as the purported will of late Mr. Sanjeev Khanna is not duly executed or proved in law or is violated by forgery, fraud, and undue influence, and is therefore null, void, and inoperative, and consequently hold that late Mr. Sanjeev Khanna is deemed to have died intestate in respect of his estate. Declare that the plaintiffs as minor of the deceased, together with the widow and mother, and any Class 1 heirs are found on record, are entitled to succeed to the estate as Class 1 heirs in accordance with the applicable law of intestate succession, and determine and they declare their respective shares in all movable, immovable, corporate trust, and other asset of the deceased. Direct the defendants to make full and true disclosure of affidavit and to render complete accounts of all assets of the deceased and every dealing, transfer, or encumbrance in respect therefore since his death, and to rectify or cause rectification of all relevant corporate, trust, and public records so as to reflect the lawful rights and shares of the Class 1 heirs are determined by this Honorable Court. Pending the final disposal of the precedent proceedings, grant appropriate interim and protective orders, including injunctions restraining the defendants from in any manner alienating, encumbering, or dissipating estate assets, and if this Honorable Court deems fit, appointment of a neutral receiver, administrator over specified assets, with liberty to this Honorable Court to permit reasonable withdrawals or maintenance and necessary expenses under its supervision. Confirm the representation of the minor plaintiffs through their mother, Mrs. Kajol Khanna, as next friend, subject to the continuing supervisory jurisdiction of this Honorable Court, and direct that no compromise or settlement affecting the minor's rights in the estate shall be valid without the prior leave to this Honorable Court. Order forensic examination of the original purported will and the disputed signatures, and should this Honorable Court find prima facie material of forgery or related offences, direct initiation of appropriate proceedings before the competent authorities, together with such cost, including exemplary cost and any other of further reliefs as this Honorable Court may deem fit in the interest of the justice. Thank you, Lordship.
Whether Prisha Khanna was aware about will deed?
She was aware, but she did not disclose in the meetings in the condolence ceremony of Mr. late Sanjeev Khanna from 14 to 17 June, which was held that.
She was aware.
But
About
she
the
did
will.
not. But she did not disclose that will when all the members of the family gathered in United Kingdom of Brits.
When she was aware, it means that Sanjeev Khanna has executed will deed.
But she did not mention
How
that.
fabrication will come in picture.
She did not mention that a will is being left by late Sanjeev Khanna when all the members from 14 to 17 June met in United Kingdom of Brits for the condolence ceremony of late Sanjeev Khanna. That shows that it was her
Whether non-disclosure means fabricating the will deed,
It
she
is-
was aware about the will, but she has suppressed. This is different thing. So why she may again fabricate the will? Sanjeev Khanna has executed will. This fact was known to this Prisha. Huh?
Prisha Khanna is the second wife of the
Second wife. She was knowing. Then where is the question of preparation of this fabrication of will?
The plaintiffs are challenging that the will is fabricated because the Sanjeev, as the Shruti Suram Malhotra has admitted in an affidavit that she left before the signing of both the witnesses in the presence of testator, and she is also telling that late Mr. Sanjeev Khanna appeared to be in a composed state of mind. She cannot confirm that the late Sanjeev Khanna was in a composed state of mind. That's why the plaintiffs are challenging that the will is forged and fabricated and caused due to undue influence. Thank you, Your Lordship.
Much obliged. In the matter of in the matter of Samira Khanna, Kiran Khanna versus Prisha Khanna, we as a council represent the respondent side. With your permission, my lordship, can I state the fact? Issue? Okay. Your lordship, please refer to page number 12. Argument advance. The Shruti Suri Malhotra and Amit Mehta was present on same date and place as the attested witness. Even Shruti Suri Malhotra left before the signing was complete. It has completed the requirement of section 67 and 70 of Bharatiya Saksha Abhinayam. Section 67 of BSA mandates proof by attest. One attesting witness as per the Annexure B proves that execution of will is valid. With your lordship permission, can I proceed to issue number 2? It is humbly submitted that the allegation of fraud and forgery must prove beyond reasonable doubt in the civil proceeding. The plaintiff has burden of proof under section 104 BSA. The transaction of 15 crore done before the death of testator. The testator was sound mind and competent to ask about the transaction. The Sanjeev Khanna had already constituted to family trust for Samira Khanna and Kiran Khanna and others, which exploit state the purported will is valid. Section 338 of BNS 2023 does not attract criminal liability. Plaintiff couldn't prove the prima facie, which is more necessary in criminal cases. With your permission, may I proceed to issue number 3? It is humbly submitted that the seal cover and compel about the NDAs violate the right of privacy under Article 21 of the Indian Constitution. The defendant argue to protect rupees 30,000 crore estate from the public speculation and media trial as per Annexure E, public disclosure of detailed assets, its high risk for business and shareholders. NDA is problematic to Khanna industry. There is a big loss and high risk for Khanna industries. With your permission, my co-counsel will argue with the next issues.
Your Lordships, Council seek permission to proceed issue number 4. It is humbly submitted that the interim relief requires the 3 tests main, prima facie case, balance of convenience and irreparable loss under Order 39 of CPC. Whereas the plaintiff don't have any proof for prima facie first for forgery. Doubt and suspicious circumstances cannot prove it is prima facie case. In favor of balance of convenience as freezing assets, it would disturb business, family needs and cause would irreparable to Khanna Industries and its shareholders. As per the Annexure E, in the case of Dalpat Kumar versus Prahlad Singh, Supreme Court clarified prima facie means there should be serious dispute and interim relief was not justified based on the fact of this case. Here, plaintiffs have lack of prima facie, so relief should be denied. Counsel seek permission to proceed issue number 5. Much obliged. Whether the suit is maintainable with Kajal Khanna acting as next friend and whether her interests are adverse to minors. It is humbly submitted that person may act as next friend of minor but interest of such a person should not adverse in the minors. Interest under Order 32, Rule 4 of CPC. Kajal Khanna act as next friend. The Sanjeev Khanna as per Annexure A already established family trust in 2018 for Samir Khanna and Kiran Khanna. There is no need to create dispute to gain 30,000 crore. Here Kajal Khanna clearly shows that the adverse interest to the minor's interest. Court may remove the next friend under Order 32 Rule 9 of CPC. The suit is not maintainable. Kajal Khanna is monitoring her interest acting as next friend. Defendant requests to remove Kajal Khanna as a next friend. Counsel seek permission to proceed issue number 6. Much obliged. In the event the purported will is set aside whether the estate devolves by intestacy under the Hindu Succession Act 1956 and the respective shares of class 1 heirs, whether the direction of account, transfer of asset or compensatory relief are warranted, whether criminal proceeding or other consequences follow absent proof fraud. It's humbly submitted that Sanjeev Khanna was polo player. It means he was physically fit, competent and conscious when he made the will. It's valid will, no question of undue influence and no question of intestate succession under section 10 of Hindu Succession Act 1956. Section 67 of Bharatiya Saksha Adhiniyam require that at least one witness to prove purpose of execution. There is no question of forgery under section 338 of Bharatiya Nyaya Sanhita and rupees 15 crore was transferred. Banking transaction made while deceased was alive as per Annexure C. He could have took on objection on transaction if it was fraud. Plaintiff don't have any clear proof for forgery. There is no attract any criminal liability. Section 70 of BSA state that attesting witnesses fail to prove the execution of document, the document's execution can still proven by other evidence. With your permission, your lordships, may I move for prayer? Much obliged. In the light of the facts stated, arguments advanced and authorities cited, it is most humbly and respectfully prayed that Honorable Court may be pleased to dismiss the plaintiff suits with costs, declare the will dated 21st March 2055 valid and binding, uphold the sealed cover order, deny all interim relief, pass any other orders as deemed fit in the best interest of justice, fairness, equity and good conscience. And for this act of kindness, the counsel for the defendant shall duty bound forever pray. Much obliged.
The counsel seeks permission to continue with rebuttal round. Much obliged, Your Lord. My lord, the learned counsel argued that the objection could be taken while the transfer of 15 crore rupees was done to Prisha Khanna from the Zenith Bank account of late Mr. Sanjeev Khanna. My lord, this could be a possible fact that Sanjeev Khanna was not aware of the 15 crore rupees transfer. Also, they argued that there were two trusts which were constituted in the names of Samira Khanna and Kiran Khanna in 2018. However, the Ministry of Corporate Affairs, hereinafter referred to as MCA, has shown the sole beneficiary of Prisha Khanna and her son Azhar Khanna, excluding Samira Khanna and Kiran Khanna. Also, my lord, the councils are continuously relying on public trial and media disclosure, but the most important fact which is being ignored here is the minors are most vulnerable stakeholders in the estate. Their interest cannot be ignored. They are insisting on removing Kajol Khanna, but they have failed to provide any proof which could show the adverse interest of Kajol Khanna. Also, there is no kind of proof where Sanjeev Khanna had provided any kind of alimony or had any kind of fight or quarrel with Kajol Khanna prior to their divorce or after their divorce. Also, they rely on the affidavit of Shruti Suri Malhotra, but then it is mentioned in the affidavit that she left before the signing was complete and cannot confirm whether the both testator's signed. Also, my lord, the councils are forgetting the one more fact which is stated in the proposition, that the deceased mother, Mrs. Renu Khanna, was forced to sign certain documents at the annual general meeting, causing a delay. She was not aware of what were the documents, and then too they was signed. Circumstances such as unnatural exclusion, involvement of beneficiary in execution, lack of evidence of sound mind, or any kind of unexplained financial transfer create suspicious circumstances. Total exclusion of wife and children without cogent explanation coupled with financial transfers favor the sole beneficiary. Despite continuous travel and interactions with the children from the first wife and his mother, Sanjeev Khanna was testamentary silent. Once the property is transferred, alienated, or transferred to any other third party, the restoration becomes impossible. The plaintiffs do not seek operational paralysis of Khanna Industries, they seek preservation of the disputed estate assets pending adjudication. The validity of the will, substantial financial transfers preceding death, and exclusion of Class 1 hires undoubtedly raise serial tribal issues. The Order 32, Rule 4 of the CPC permits any person of sound mind and majority to act as the next friend, provided his interests are not adverse to that minor. Here, the next friend is the mother of the minors, and the adverse interest of the mother, that is Kajol Khanna, are not clearly shown, and any kind of proof is not provided by the learned counsels. This test is actual conflict and not a presumed hostility.
All right, got it. Thank you. Thank you. Whether you want to say anything?
Yes.
On what point?
Your Lordships, Council seek permission to address the front page of the memorial of this plaintiff. Plaintiff show Section 18 of Indian Succession Act. There is no relevancy of this case.
ठीक.
Much obliged.